They laughed at my disabled son in court. 6 months later, the entire HOA board was removed and facing criminal charges. Here's how a father and son brought down a corrupt homeowners association. I never thought I'd be telling this story publicly, but after what my family went through, I feel others need to hear it. My name is Daniel, and my son Jake has cerebral palsy. He's the smartest person I know. Graduated top of his class in law school despite facing challenges most people couldn't imagine. This is the story of how our HOA tried to humiliate him, and how he used his legal knowledge to not just win against them, but completely dismantle their corrupt organization. It started 3 years ago when we moved into Oak Ridge Estates, an upscale neighborhood with well-maintained homes and what seemed like a tight community. The house was perfect for Jake, single-level, wide doorways and a flat driveway that made it easier for him to navigate with his wheelchair. The first month was peaceful. Neighbors brought welcome baskets, and everyone seemed friendly. I remember thinking we'd finally found our forever home. Jake was settling into his new job at a law firm specializing in disability rights, and I was enjoying my retirement after 30 years as a high school teacher. Everything changed when we received our first letter from the HOA. The letter stated we were in violation of community guidelines because we had installed a small ramp at our front entrance without prior approval. I was confused since the previous owner had mentioned that accessibility modifications were permitted. I called Martha Winters, the HOA president, to explain that the ramp was necessary for Jake's mobility. Her response shocked me. "I understand your situation, but rules are rules," she said coldly. "You'll need to submit a formal application, pay the $500 review fee, and wait for board approval. Until then, you'll be fined $50 daily for the unauthorized modification." I tried to explain that removing the ramp would effectively trap Jake inside our home, but Martha wouldn't budge. When I mentioned the Americans with Disabilities Act, she laughed and said, "Private communities have different standards. You should have read the fine print before moving in." That evening, I told Jake about the conversation. Instead of getting upset, he calmly opened his laptop and started researching. "Dad," he said after an hour, "they can't do this. The Fair Housing Act explicitly protects reasonable modifications for disabled residents. We don't need their permission for accessibility features." Jake drafted a response letter citing the relevant laws and sent it to the HOA board. We thought that would resolve the issue, just a misunderstanding that needed clarification. We were wrong. The next morning, 2 board members came to our house unannounced. They took pictures of our ramp, the wheelchair lift on my car, and even peered through windows to document other modifications we'd made inside. When I confronted them, one of them, a man named Richard Cooper, smirked and said, "You should teach your son about respecting authority before sending threatening letters." That night, we received an email from the HOA with an expanded list of violations: the ramp, a handrail we'd installed in the bathroom, the texture of our doorknobs, and even the height of Jake's raised garden beds in the backyard. The total fines now exceeded $3,000. Jake spent the whole night reviewing the HOA bylaws and regulations. By morning, he had discovered something disturbing. None of the violations they cited were actually in the official documents we'd received when purchasing the home. "Dad," Jake said, his voice steady but serious, "I think they're making up rules specifically to target us. The bylaws they provided during closing are different from what they're enforcing now." We decided to attend the next board meeting to address these inconsistencies. When we arrived, the conference room at the community center wasn't wheelchair accessible. There was a steep set of 3 steps with no ramp. Jake had to wait outside while I went in to ask for accommodation. Instead of helping, Martha announced to everyone present, "It seems we have someone who can't follow simple rules and now wants special treatment to attend our meeting." Several board members chuckled, and Richard openly said, If they can't even get into the building, maybe they shouldn't live here. I was furious but kept my composure. I recorded their comments on my phone and went outside to tell Jake. He nodded, took a deep breath, and said, "Let's document everything. This isn't just about us anymore." Over the next 2 weeks, we learned we weren't alone. Several elderly residents and another family with a disabled child had faced similar treatment. They'd been intimidated into compliance or forced to move out. Jake began collecting their stories, building what he called a pattern of discriminatory behavior. Meanwhile, the fines kept accumulating. When we refused to pay, the HOA placed a lien on our house and initiated foreclosure proceedings. They were literally trying to take our home because we installed a wheelchair ramp. That's when Jake suggested we take legal action. Not just a complaint or a small claims case. He wanted to file a federal lawsuit against the HOA for violating the Fair Housing Act, the Americans with Disabilities Act, and several state laws protecting disabled residents. I was hesitant. Legal battles are expensive and draining. "Are you sure about this, Jake?" I asked. "These people seem powerful in the community." Jake looked at me with determination I hadn't seen since his law school finals. "Dad, what they're doing isn't just unfair. It's illegal. And they're doing it to people who can't fight back. Someone needs to stop them." We filed the lawsuit the next day. Jake insisted on representing us himself, despite offers from colleagues at his firm to take the case. "This is personal," he explained. "I need to be the one facing them in court." The HOA's response was immediate and aggressive. They hired Stevenson and Blake, one of the most expensive law firms in the state. Their lead attorney, William Blake, had a reputation for ruthlessly dismantling opposition. Their strategy was clear: overwhelm us with legal paperwork and drain our resources before we ever got to trial. They filed motion after motion trying to get our case dismissed. They demanded thousands of pages of documentation about Jake's disability, our finances, and even my employment history. They were clearly trying to bury us in paperwork. What they didn't understand was that Jake thrived on legal challenges. Each motion they filed, he countered brilliantly. When they claimed the HOA wasn't subject to federal housing laws, Jake cited 3 precedent cases proving they were. When they argued his modifications decreased property values, he produced market analyses showing accessible homes actually sold for higher prices in our area. During the discovery phase, Jake requested all HOA board meeting minutes, financial records, and communications regarding our property. The HOA attorneys fought this vigorously, claiming it was overly broad and burdensome. Jake convinced the judge these documents were essential to proving a pattern of discrimination. When the records finally arrived, Jake spent 3 days going through everything. What he found was worse than we imagined. "Dad," he said, looking up from his computer at 2 a.m., "they've been changing the bylaws without proper votes. They've been imposing fines that aren't authorized. And the worst part? They've been pocketing most of the money." The financial record showed that of the nearly $800,000 collected in dues and fines over the past 3 years, less than 30% went to community maintenance or improvements. The rest disappeared into vague administrative expenses or legal consultations that all seemed to trace back to companies owned by board members or their relatives. Jake also discovered that Richard Cooper, who seemed particularly hostile toward us, had previously been sued for disability discrimination at his business. That case had been settled privately, and the record sealed. However, the HOA had paid his legal fees from community funds, a clear conflict of interest. Armed with this information, Jake amended our lawsuit to include fraud, embezzlement, and breach of fiduciary duty. He also contacted other homeowners to share what we'd found. Many were shocked and angry. A group of 28 families joined our lawsuit, turning it into a class action. The HOA board panicked. They called an emergency meeting and tried to vote in retroactive approvals for all their financial decisions. Jake attended this time. We'd forced them to move to an accessible venue and recorded everything. When Martha tried to rush through votes without proper procedure, Jake calmly cited the bylaws that prohibited such actions. "You don't understand how things work here," Martha snapped, clearly flustered. "Actually," Jake replied calmly, "I understand exactly how things have been working here. That's the problem." As the case proceeded toward trial, the HOA's attorneys approached us with a settlement offer. They would waive all our fines, approve all reasonable accommodations, and pay $25,000 in damages if we dropped the lawsuit and signed a non-disclosure agreement. Jake didn't even consider it. "This isn't about money," he told me. "It's about accountability and making sure they can't do this to anyone else." The case finally went to court 6 months after we filed. The HOA's attorney tried to paint us as troublemakers who wanted special privileges. He argued that the community's aesthetic standards would be compromised by accessibility modifications, and that Jake was using his disability to circumvent reasonable regulations. Then came the moment that changed everything. During Jake's cross-examination, William Blake tried to undermine his credibility. "Mr. Reynolds," he said condescendingly, "you claim the HOA discriminated against you. But isn't it true that you've been looking for a fight since you moved in? Isn't this lawsuit just an attempt to extort money from hard-working community volunteers?" The courtroom went silent. Jake wheeled his chair closer to the stand, looked Blake directly in the eyes, and spoke clearly into the microphone. "When I was 12, he began, "my doctor told me I would never walk again. When I was 16, my high school counselor said I shouldn't bother applying to college because it would be too difficult. When I applied to law school, an admissions officer suggested I consider a less demanding career. My entire life, people have told me what I can't do, what I shouldn't attempt, what's reasonable to expect from someone like me." Jake paused, his voice steady. "But here's what I've learned. Those limitations exist only in other people's minds. I don't need special treatment. I don't want exceptions. I simply want the same rights as everyone else. To live in my home, to enter buildings, to exist in public spaces without having to justify my presence." He pointed to the HOA board members sitting at the defense table. These people didn't just violate housing laws. They attempted to use their power to decide who belongs in their community and who doesn't. They enforced rules that don't exist and punished those who couldn't or wouldn't comply. That's not protecting property values. That's discrimination. And it stops today. The courtroom was completely silent. Even Blake seemed momentarily speechless. But what happened next shocked everyone. Richard Cooper stood up from the defense table and shouted, "This is ridiculous. We shouldn't have to change our entire community because one person can't use stairs." The judge immediately called for order, but the damage was done. Cooper's outburst revealed exactly the attitude we were fighting against. Several jurors visibly recoiled at his words. After that, the case moved quickly. The financial evidence was damning. Board members began turning on each other, with Martha claiming Richard had made financial decisions without proper approval, and others suggesting Martha had edited meeting minutes to cover improper votes. Their defense crumbled. Climax, key, moment. The verdict came after just 2 days of deliberation. The jury found the HOA had violated federal housing laws, engaged in discriminatory practices, and breached their fiduciary duties to homeowners. They awarded our class action group $3.2 million in damages, with specific provisions for those who had faced disability discrimination. But the judge wasn't finished. In her final ruling, she dissolved the current HOA board, ordered a forensic audit of all financial records, and referred evidence of embezzlement to the district attorney's office. She also mandated that all HOA meetings must be held in accessible locations, and that the bylaws be amended to explicitly comply with federal accessibility standards. As Martha, Richard, and the other board members left the courtroom, I expected to feel triumphant. Instead, I just felt relieved. Jake, however, was already thinking ahead. "This isn't just about our community," he said as we headed home. "This case creates precedent for other HOAs across the state. That's the real victory." The aftermath was swift. 3 former board members, including Martha and Richard, were arrested on charges of fraud and embezzlement 2 weeks later. The forensic audit revealed they had diverted over $400,000 of HOA funds for personal use over 5 years. Our neighbors, many of whom had been afraid to speak up before, stopped by to thank us. Several admitted they'd noticed problems but feared retaliation if they questioned the board. An elderly couple brought homemade cookies and tearfully explained how they'd almost lost their home to similar unnecessary fines. The most meaningful reaction came from a young couple down the street. Their daughter had muscular dystrophy, and they'd been afraid to install the bathroom modifications she needed. "Because of you," the mother told Jake, "she can now live in a home that's built for her needs, not against them." A new HOA board was elected, with representation from diverse homeowners, including elderly residents and families with disabilities. They immediately approved a set of transparent, fair bylaws that explicitly protected reasonable accommodations. Jake was asked to serve as a legal advisor during the transition. The ramp at our front door remained, of course, but it now represented something beyond access to our home. It symbolized standing up against discrimination and the power of knowing your rights.